All right. Hopefully everyone can hear me. Good afternoon, everybody. Welcome to another Beresford Booth lunchtime webinar. Today's subject is on the Washington Silence No More Act, and specifically what employers need to know in order to make sure that they're in compliance with this act. This is a recent Washington law that was put into effect earlier mid this year, and has some particular impacts on how employers should handle their non-disparagement and their non-disclosure clauses. And so let's just get rolling with it. So before we get into the meat and potatoes here, just as a quick introduction, I am Dexter Bradford. I am a recent Seattle U Law grad. And I've joined Beresford Booth on their employment law team. And in school, I worked with the Workers' Rights Clinic and had a lot of experience working in employment law specifically. And just wanted to talk about the avoiding liability under this act, because there are a few particular key points to this act that I think employers need to be aware of. It's not a particularly long act. The substance of it is not particularly long. I think the whole RCW is just a couple of pages, and if you want to read it, you can read it in 49, 44 to 10. It went into effect June 9th of this year. I think it's just 3 pages long, but there are key points that we'll all touch on to make sure that you're aware of them. The first thing that it does is the Washington legislator, what they're trying to do here is make sure that there's strong public policy in favor of not preventing employees from being able to talk about illegal workplace violations, sexual harassment, wage and hour violations, things of that sort. The wrongdoing in the workplace, they're trying to make sure employees aren't prohibited from talking about that. And this law is building off of a previous 2018 Washington law that prohibited employers from requiring their employees to sign agreements that prevented sexual harassment and sexual assault. And that law was a little bit more limited in scope. It was just limited to those particular instances of sexual harassment and sexual assault. It also had a more narrow view of what they included in the definition of an employee. And as you'll see, they've made this law substantially more broad and more inclusive. It's modeled after a recent California law that went into effect in January of this year. However, the Washington law here actually has a bit more recovered underneath it. So let's go ahead and get into that. The first thing that it does is the act voids most, I say most, but it's nearly all non-disclosure and non-disparagement clauses. So from here on out in Washington, if you have a non-disclosure, non-disparagement clause, you can assume it's void, and there's a couple exceptions that I'll talk about at the end, but those agreements are going to be void. Specifically the ones in settlement agreements, referring to illegal workplace conduct, sexual harassment, sexual assault, like I said, wage and hour violations, and including any other illegal conduct that takes place in the workplace. So the next and most probably more important part is the act also makes it a violation to try and enforce any prohibited clause. So not only are non-disclosure and non-disparagement clauses now void in Washington, but there's also penalties for an employer who tries to enforce these. So it's a very good thing to be aware of. If you're not aware of this, you better make sure that your forms are compliant with these requirements. You're probably going to want to take these out. Specifically, the statutory language says that it is a violation of the section for an employer to request or require that an employee enter into an agreement provision that is prohibited by this section. And it's a violation for an employer to attempt to enforce a provision of an agreement prohibited by this section, whether through lawsuit, whether through a threat to enforce, or any other attempt to influence a party to comply with the provision. So any other attempt to influence a party to sign one of these agreements or to enter in one of these agreements is going to be a violation of this section. So this act specifically applies to employment agreements That's what it was intended to target, but it also includes independent contractor agreements. If you're making any sort of agreement with someone who could be an employee or an independent contractor, this statute applies, or any agreements to pay compensation for a relief claim, so a settlement claim. Any other agreement between an employee or an employer. Like I said, it's very, very broad. They meant to include as many people as they possibly could in this. They're trying to pretty much just do away with non-disparagement and non-disclosure agreements altogether, except in a couple instances. So it makes it a violation for employers also to retaliate against their employees. Now, this section is really noteworthy because of the last part of this sentence here. So it makes it a violation for employers to retaliate or discharge against an employee who discussed conduct the employee reasonably believed to be illegal harassment, discrimination, retaliation, wage and hour violations, or sexual assault. So this could cause potential problems for an employer who, let's say, for instance, you've got a particularly problematic employee, and this employee is making all sorts of accusations about the company. They're, horrible, they're doing this, and you want to get rid of this employee. And one of the things this employee is alleging in their litany of things they're saying against this hypothetical scenario, but and they're saying, oh, they don't pay me correctly, and you fire this employee, that employee might have a claim against you. They might come back to say that you retaliated against them for them reasonably believing that they had a wage and hour violation. Now, it doesn't say that there actually has to be a wage and hour violation, just that the employee needs to reasonably believe it. So if that employee had a reasonable belief that they weren't being paid properly and they were fired, and they can show that they were fired because they were talking about this, then you're facing the civil penalties, which I'll explain in a little bit, but they are significant and it's definitely something to be aware of. The next key note or key worthy thing here is that it applies to all Washington resident employees. And this section is particularly interesting if you are, let's say you're an out-of-state employer and you hire employees all across the country, or maybe you have several remote employees, or maybe you're primarily in Montana, but you have a couple remote employees in Washington. There's a section in this statute that states that a non-disclosure or non-disparagement provision in any agreement signed by an employee who is a Washington resident is governed by Washington law. And at first glance, it doesn't seem like much, but what this is saying is there's no workaround to signing an employee. Like, let's say you're Montana, but you sign an employee from Washington and you just include the non-disparagement, non-disclosure agreements in your employment contract, and then you say in your choice of law provision, oh, well, Washington law, it won't apply, Montana law is going to apply to this agreement. Well, that's too bad for the non-disclosure, non-disparagement portion of the agreement. Washington law will still apply, and this still applies to that particular employee. So you'll still find yourself in violation of the law for trying to enforce these prohibited clauses. So very, very important to note there, if you are, not even an out-of-state employee, Washington employers are susceptible to this as well. But if you're an out-of-state employer and you're thinking that this isn't going to apply to you, if you have any Washington employees, you need to be aware of this, which I know is particularly difficult in the remote work age that we're in now, to keep track of where all your employees are. So it becomes even more significant now to make sure that you know where your employees are located, whether they're a resident of Washington state, because you need to make sure that if they are, you're not trying to enforce any of these provisions. So the last probably noteworthy thing of this statute was that it applies retroactively. So not only are your non-disparagement, non-disclosure employee clauses void from June 9th forward, but also all of the non-disparagement clauses, non-disclosure clauses in your employment agreements from June 9th backward are also going to be completely void. Now, I want to know that you don't have to do anything with the past employees. If you had an employee pre-June 9th of this year that signed a non-disclosure or non-disparagement clause in their employment agreement, you don't have to go back and have them sign a new one, but you cannot enforce that. You cannot suggest, it's better to not talk about it. You cannot even pretend to or insinuate that you would enforce that clause, because it's void and unenforceable. And suggesting that you might enforce it can land you in civil penalties land. And the other thing that the statute mentioned was this retroactivity doesn't apply to non-disclosure, non-disparagement agreements in settling a legal claim. So if pre-June 9th, you settled a claim with an employee for whatever reason, and pre-June 9th of this year, you included in that there was a non-disclosure, non-disparagement clause in that settlement agreement, that agreement's still enforceable. There was a carve out for those specifically. So, but every settlement agreement after June 9th needs to not have those in it. Pre-June 9th, you're okay. So if you have an employee or someone maybe misread this law and they think that they can go out and say whatever they want now, even though they signed this pre-June 9th, you can still enforce that. But again, post June 9th, no non-disparagement, non-disclosures. And like I said, the civil penalties are noteworthy here. It's a minimum fine of $10,000 for any violation of the statute. Plus, employees can bring their own private civil action against you and have their attorney's fees covered. So nothing to scoff at. You don't want to be getting penalties left and right for including these things that are probably just sitting in your standard forms and are being sent out. We want to make sure that those are getting taken care of. So there are a couple of exceptions. Like I mentioned before, the bulk of the non-disclosure, non-disparagement agreements are gone, except for if you're a tech company and you're worried about your trade secrets or proprietary information. That stuff, those clauses are fine. Those are not covered. The purpose of the law wasn't to make everything known, including trade secrets and proprietary information. It's more to protect employees, to make sure that they have a voice and they're able to talk about any sort of misconduct or illegal activity that was happening in their workplace. And then the other thing that was exempted from this was settlement amounts. You can't have a non-disclosure, non-disparagement agreement in your settlement contracts. You can't prevent an employee from talking about the context of the settlement, or there was a settlement, but you can prevent them from talking about what the settlement amount was. So you can have a clause saying that they're not allowed to talk about the amount of settlement money that they received in that contract. So as an employer, what should you do? You need to make sure that your forms, all of your employment forms, are reviewed and updated to make sure that they're in compliance with this new law. Even if you're an out-of-state, if you're not a Washington employer, you should consult with an attorney. You should have them reviewed and looked at, especially anytime you know that you could be dealing with a current, former, or prospective employee or independent contractor. You should have someone review specifically your employee handbook policies, broad employment agreements, arbitration agreements, NDA, confidentiality agreements, non-disparagement agreements, specifically proprietary information, invention assignment agreements, severance agreements, and definitely your settlement agreements. All those forms need to be updated. You really don't want to just be sending out these forms and then find that you sent out 10, 50, 100 illegal forms and then get hit with a bunch of civil penalties for failing to update these, because it's not a huge change. It's just a couple updates that you need to make to your forms, but it's something really easy to overlook. Again, do not try and enforce any prohibited clauses, any of those clauses, non-disparagement, non-disclosures that we talked about. Do not try and enforce any of those. And most importantly, update your leaders. If you're an employer, make sure that you discuss this with your managers, all the people running your company. Most of these cases just arise from people who were unaware of the change or didn't get the memo and tried to do something like enforce one of these clauses they didn't know were now illegal. So make sure you just take the time to update your forms, update your leaders, and you should be good to go. If you have any questions about compliance with this, you can email me or give us a call here. We have a bunch of wonderful employment law attorneys that can look over these forms for you and make sure that you're in compliance with the law. And that's it for today. Like I said, it was going to be a pretty short one. It's not a lot of meat and potatoes to this one, but it is important nonetheless to make sure that you are in compliance and you avoid those civil penalties, because you don't want to get hit with those. So thanks for tuning in today. Like I said, if you have any questions, feel free to give us a call.